Hi there to everyone that has joined recently. As a starting point, I'd like to say thank you to Absa WIP for hosting this session. For those that don't know, Work in Progress is an Absa innovation lab and a co-working space at the Woodstock Exchange in Cape Town, South Africa. As a bit of background, I would have liked to have run this workshop at Work in Progress in real life, but for reasons that we're all well aware of, we've taken this workshop into the virtual world. Once again, thanks for being here with me today. I'd like to ask that you direct all your questions to the comments section on the feed. We are collating these questions and I'll address as many as I can at the end of the session. You're also welcome to mail your questions to cpt@workinprogress.co.za and I'll respond directly to you. You'll give me a minute. I just want to upload my presentation. Perfect. I hope that you can all see my screen. Oh, sorry about that. Sorry, I'm just trying to find my other screen at the moment. There we go. All right. So I've been fortunate enough that during my career, I've been involved in various investment deals, which have included investors acquiring shares in SMEs and startups. And I would like to discuss with you some of the insights that I've gained from these transactions. When an investor approaches me to attend to the investment deal, the first step in the actual deal process is a legal due diligence investigation. For those that have never heard the term legal due diligence investigation, it's something similar to a forensic investigation. This is an investigation whereby several different documentations are requested by me from the SME or startup. I then review these documentation and provide a report to the investor. The documentation that I request from the SME and startup is typically documentation which relates to the existence of the company, existence of the business which is undertaken by the company, shareholding, are there any disputes, or the contracts that have been entered into. The report which I submit to the investor will set out all of the issues which I have raised, as well as what are the risks to the investor in making its investment into the company. During these investigations, I have noted time and time again that the same matters are being raised by me when an investor wants to invest into an SME and a startup. These matters either result in the actual deal being more complex than what it has to be, or the investor deciding that it would rather pass on investing in the SME or startup. To better illustrate this, here is an example of an actual transaction which I dealt with recently. Oh, sorry. My client was an SME in the technology industry. It was approached by one of the largest investors in South Africa, who, after an initial assessment, agreed to purchase 25.1% of the company for an initial investment of 65 million rand. During the due diligence investigations that were conducted by the investor's attorneys, it transpired that my client had certain corporate governance issues and that there were individuals who should have been issued shares but weren't. As a result of this and other matters, the investor reduced the purchase price to 45 million rand. In addition, in order to resolve issues that had arisen with the individuals who should have been issued shares, my client was required to pay such individuals a settlement amount of 12 million rand. My client, therefore, should have received an investment of 65 million rand, but only received an investment of 33 million rand. I think that we can all agree that with everything going on in the world right now, it is more important than ever to ensure that you provide any potential investor with the least opportunity to either pass on investing in your SME or startup or reducing its investment amount. We have noted a slowdown in investment activity, but a slowdown does not mean that investment activity is non-existent. It only means that investors are being more selective about the investment opportunities they wish to pursue. As such, I have highlighted in this webinar those matters which may make investors nervous when looking to invest in SMEs and startups. It must be kept in mind that the seasoned investor usually anticipates that these matters will be in existence when investing into an SME and startup. However, whereas in the past they may have been comfortable to take on the additional risk, they may not wish to do so now. The first matter I wish to discuss is organizational structure. When an investor makes the decision to invest, there will be a discussion as to the way in which such investment will take place. Now, investments can either be by means of debt funding, where the investor actually provides a loan into your organization, or it can be equity funding, where the investor actually decides to purchase an interest in your organization. But in order for the investor to make such a decision, there needs to be an organizational structure in place, which means that the business needs to be undertaken in a separate legal entity. This is typically either a company or a closed corporation. Closed corporation was popular prior to 2011, as there was no requirement to have the annual financial statements audited, and the legislation which governed this type of entity was easier to navigate. In 2011, a new Companies Act came into force, which simplified the corporate landscape. For this reason, investors prefer investing into companies. Also, if your investor is a foreign national or a foreign entity, it will be most likely that they will wish to invest in a company, as a company is a universally recognized structure. It might be subject to different legal requirements based on the jurisdiction in which the company is registered, but it is still universally recognized. Where an SME or startup is run by a sole proprietor, which means there's no separate legal entity, or the business is being run in a closed corporation, investors would typically require that such structure be converted into a company. The conversion process requires the involvement of third-party institutions, such as the Companies and Intellectual Property Commission. Now, if any of you have ever dealt with CIPC, you know that the period for processing is either very quick or very slow. Although the conversion process itself isn't complex, it will result in a delay in the completion of the transaction, as the investor will only be able to invest once the structure is in place. It is therefore important to ensure that from the start of the investment process, you have a structure in place which an investor can comfortably provide its investment to. The next is corporate governance. Those of you who are currently trading our companies will no doubt have purchased those companies as shelf companies, meaning those companies were pre-registered by firms whose business it is to sell existing companies. You purchase such shelf companies. When you purchase these shelf companies, the firms attended to the changes which were required to be made in order for them to become yours. For example, changing the name, changing the directors, changing the shareholding registered address, etc. Although this is the easiest way for companies to come into existence, there are certain company secretarial obligations which remain with you as the owner of such companies, unless you employ somebody else to attend to it on your behalf. For example, do you know that a company is required to have a share register? This is a register which sets out certain details of the company, such as its registered address, the directors, shareholders, any changes in the share capital of the company. If you do not have a share register, you are not in compliance with the company's legislation. This means that prior to the investment, the share register may need to be created or updated, and will add a level of complexity to the deal as the investor tries to mitigate its risk. In addition to this, it must be kept in mind that a closed corporation or a company is a separate legal entity from you, as the individual who owns the interest in it. This means that you cannot merely enter into an agreement or an arrangement on behalf of the company without being authorized to do so. If you don't have the relevant authority, this could have serious liability implications for you in your capacity as a director of the company. Authority is given by means of a resolution passed by the company, which not only authorizes you to act on behalf of the company, but also authorizes the agreement or the arrangement. It must be kept in mind that in certain instances where you, in your capacity as director, can't act until a decision has been passed by the shareholders of the company. Now, this may seem arbitrary, where you are the sole director and sole shareholder of the company, but it must be kept in mind that this is a requirement of law and therefore needs to be complied with. Investors will require you to rectify any non-compliance, which not only takes time, but in some instances can only be done with court action. We can all agree that court action is not only timely, but it is very costly. And in some instances, an investor may rather decide to pass on the investment. Lastly, on this topic, a company is required to submit annual returns each year to SIBC. But are you aware that even where a company doesn't trade or hasn't earned any revenue, is still required to submit its annual returns? Failure to do so results in SIBC commencing a process of deregistration of a company due to non-compliance with the annual return submission. You don't want to be in a position whereby you walk a path with an investor. They agree to invest in your company, only to find out that you are in the process of being deregistered. This may not scare an investor off, but there is a process which needs to be followed and documents which need to be submitted to SIBC in order for the company to be removed from the deregistration process. This is time that could have been spent on finalizing the deal and working on further developing new products. Contractual arrangements. As I've indicated under the corporate governance section, you will need to ensure that you have the authority to enter into any contract. Also, copies should be kept of any contracts entered into so that you have a document to work from in the event of a dispute. Nobody likes to think of the worst case scenario when you're entering into a contract, but it's always best to be safe rather than sorry. Although a contract can be entered into verbally under South African law, remember that it is very difficult to prove the terms of a verbal contract because nothing is set in writing. If there is some reluctance on the part of your contracting party to actually reduce the terms of your agreement into writing, it may be best for you then to record the main terms in an email format. This will provide you with a base to work from in the event of a dispute. Also, if these are the types of agreements that you're entering into on a regular basis, it may be best to have a standard agreement that you can work from and at least enter into. Any agreement which relates to a crucial portion of your business should always be reduced to writing, as this is what will actually be purchased by an investor. If there is only a verbal agreement in place, there is a risk for the investor, that the other contracting party may place a claim on your business, or that the other contracting party may cancel the contract and thereby, for example, reduce the revenue of the company. The most important agreement which you should always try and enter into is a confidentiality and non-disclosure agreement. This is especially important where you have third-party service providers who you send or provide confidential information to. You do not want to be in a position where a similar product to yours is released to the market due to the fact that someone has re-engineered your confidential information. It is also important for the investor to know that you have secured your confidential information, as this is vital to the business and is the reason the investor is making an investment into your organization. Please be aware of any service provider who indicates that you may pay them by issuing shares to them in future. This may turn out to be lucrative for them, but is not an effective method of payment, and often ends in a dispute as to the number of shares which are to be issued and under what circumstances these shares are going to be issued. Written service level agreements should always be entered into, as it provides the investor with an indication as to the terms upon which a third party is rendering services to your organization, as well as what protection measures you have put in place. Employment aspects. Terms of employment should always be reduced to writing. This is not only applicable to third-party employees, which you may have, but also in respect of yourself. Remember that you are an employee of the organization just as much as you are a founder, shareholder, or director. Also, keep in mind that our employment legislation regarding independent contractors is complex, and that in certain instances, an independent contractor may be considered an employee of your company. This is a risk for investors as there is a potential labor dispute which may arise between you and the independent contractor as to the nature of your relationship. Make sure that you have an agreement in place with your service providers, which makes it clear as to the nature of the relationship between you. You don't want to be in a situation where an independent contractor claims to be an employee of your organization. Investors don't want to be in a situation where they have a potential labor dispute on their hands. Intellectual property. It is important for all companies which are technology driven or have extensive intellectual property to ensure that they are actually the owners of such intellectual property. This is particularly important when any portion of the research and development of the intellectual property is outsourced to a third party. You will need to ensure, typically by means of an agreement, that any intellectual property developed by a third party is actually owned by you. You can imagine that where an investor wishes to invest in a company and there is any doubt as to who owns the intellectual property, they will rather not make the investment into such company or add a level of complexity to the investment deal, which results in the founding owners of the company being held responsible for any lack of ownership. I've actually had experience in this sort of matter. I was required to provide an opinion to a client who had actually requested a friend to do some research and development for them. It was in respect of designing a formula. And that friend was employed by somebody else. And it turned out that there was a potential risk that the actual formula being developed was actually owned by the employer of the friend as opposed to my client. So please be careful in this regard. Since the lockdown of various countries as a result of COVID-19 epidemic, there has been a sharp increase in hacking attempts and phishing scams. Although South Africa's data protection legislation in the form of the Protection of Personal Information Act has yet to come into force and effect, we are seeing that more investors are requiring companies to indicate the level of their compliance with this legislation. To this extent, you need to determine what personal information is being processed through your organization. This information may be about employees, service providers, even applicants for employment in the form of their CVs being sent to you. The definition of personal information is wide, and therefore all companies will be processing some form of personal information or another. As such, you need to ensure that you have the relevant security safeguards in place. This can be as simple as ensuring that your laptops and your mobile phones have password protection, or as complex as ensuring that your documentation is encrypted. Investors who have specific data protection measures in place will in all likelihood expect their investments to have the same standard of protection. They do not want to be in a place where their investments systems are hacked and sensitive information is leaked to the public. This will have grave consequences for their reputation. Also, if your investor is a foreign national or a foreign entity, it is likely that they will be subject to very strict data protection legislation, and particularly if they work in the European countries. Therefore, they do not want to be in a position where their subsidiary has less protections than what they are actually bound by. Lastly, one must remember that when transacting with individuals or juristic persons with a turnover less than 2 million, the Consumer Protection Act will apply. As such, you need to ensure that your terms and conditions of your website or physical store comply with the various requirements of the CPA. Non-compliance is seen as a risk for investors as it may potentially result in investigation by the National Consumer Commission and even the imposing of a substantial fine. This fine can be as high as 10% of your turnover. The provisions of the CPA are not only limited to what your terms and conditions must say, but also contain provisions dealing with the recall of products. This is important as all companies who sell products to consumers are required to have a recall policy in place and to follow the recall procedures set out by the National Consumer Commission. Non-compliance of this not only has an impact from an investor perspective, but also may damage your company's reputation. This is also a risk for the investor, as not only will the actual company's reputation be affected, but also the investor itself. I've also seen in recent times that there are more competitions being held by companies in order to obtain sort of people's email addresses for marketing purposes. You must keep in mind that the CPA actually provides certain requirements in respect of promotional competitions. These requirements actually set out what your terms and conditions must say, as well as the fact that there are certain documents that you need to keep for a specific period of time, because the National Consumer Commission actually has a right to call on those documents. Lastly, the matters highlighted in this webinar are not an exhaustive list, and there may be other factors which an investor may take into consideration, which are specific to the investment of your organization. There may be items such as, are there any immovable property that you own? Is there any movable assets that you have, such as machinery? Those sorts of matters will be very specific to a transaction. I know that legal compliance is the last thing that you are thinking of now. Most of you are concerned about the survival of your business or about the way in which you can pivot your business in the changing circumstances. But unfortunately, with the change in circumstances comes investors who are looking for investments which are quicker, easier, and have less complications. Even if your goal now is not to obtain investors, it is still worthwhile to perform a quick legal compliance assessment of your organization to see how far off the mark you are, if any investor had to approach you. If the legal compliance assessment of your organization seems like a mammoth task, I'm happy to assist in this regard. Please do not hesitate to contact me via phone, email, or even a virtual call. My details are on the screen. That's it from me. Before I end, I'd like to answer some of your questions. Just give me a minute here. Right, there's a question from Charmaine. Kendall, would you suggest that SMEs outsource the corporate governance to a third legal party, as the SME may not have the skills or capacity to fulfill on a permanent basis? It's a good question, because sometimes the corporate governance can be very daunting. I think it might be a good idea, just because the last thing you want to be thinking about is trying to do the corporate governance and still trying to develop your business. But the arrangements that you enter into, you can always negotiate what that actually looks like. Sometimes, and what we sort of do, or what I provide to clients, is sort of on a retainer basis where I say, well, you know what, this is how much I'm going to charge you per month, the maximum amount. If there are any sort of corporate government aspects that we have to deal with. If there isn't, then obviously you don't get charged. At least you know that if there is a resolution that needs to get passed, or if changes need to be made to your share register, that at least it is handled by somebody who has the capacity as well as the ability to do so, and you don't then have to worry about it. Are there any other questions which we have? Always a couple of minutes. I know that I've gone quickly through these aspects in the webinar, but this is only meant to give you sort of a brief overview as to what are the items that an investor is actually looking at. They will obviously be different depending on the actual transaction. So I didn't want to go into too much detail. If you want more information, please do feel free to contact me. We do have another question from Linda. Will the startup provide investors with tax advice regarding dividends, or will the investors have to obtain this separately? Typically, investors will want this separately. It's always best to ensure that everybody obtains their sort of independent legal advice. And when it comes to tax, that's very important. Nobody wants to pay SARS more than what they have to. So typically the investor will obtain their own separate legal advice. They will, however, during the due diligence process, concentrate on tax if they are concerned about it, and just ask the normal sort of questions about, have you submitted all of your tax returns to SARS? Has there been any communication with regards to any assessments? Has there been any communication with regards to any penalties? That comes out, then obviously there are some sort of issues that we need to then sort out and that the investor will need to cater for in the legal. There's a question from Freya. What are the most common mistakes you see from SMEs? The most common mistakes, like I said, it varies over the different sort of SMEs and the industries in which they work in. But the most common for me would definitely be from a corporate governance perspective. It's the last thing that an SME sort of thinks about ensuring that it has all the resolutions in place, that it updates its share register, or even that it has a share register. People just are in the mode of getting the job done and getting the products done and entering into the relevant agreements in order to get the research and development done. And the legal stuff falls by the wayside, which, I mean, when you're focusing on developing a company, that's kind of, your most important thing is actually doing the products and developing the company itself, as opposed to worrying about the legal stuff. So those are the things that we see. Also that, contracts are entered into on a verbal basis. And then when it comes to the due diligence investigations, you've got to sort of put together what the agreement was all about, and the terms upon it, and especially when it comes to like cancellation rights and things like that, which is very difficult to do. So I would definitely suggest that if you're going to enter into an agreement, a handshake agreement is very easy to do, but your agreements actually should be reduced in writing, even if it's just in the form of a quick email. And that's not obviously the best, but it's something better than having sort of just a verbal agreement. Also, the stuff that I've seen is, when it comes to sort of protecting your confidential information and your intellectual property, that seems to sort of go by the wayside, because everybody, when they enter into an agreement, is on the basis of, oh, we're happy now, we like one another now. You're not thinking of, oh, well, if this goes south and I don't like this person anymore, what's going to happen then? And the thing is that whenever you enter into an arrangement with a person or have a discussion with a person, or you're going to send them your confidential information or intellectual property, always think to yourself, what happens if this relationship goes south and I need to get out? Can I easily secure my confidential information, or can somebody just run off with it and basically do what I wanted to do? So those are the types of things you have to be careful of when it comes to SMEs. There's a question from Bridge. Sophisticated investors should like to see a shareholders agreement in place if they take equity in the business. How do you protect your own interests regarding voting rights, but still allow them to negotiate the changes they want? So just from a little bit of a background with regards to our law, previously we had a situation where shareholders agreement trumped your memorandum of incorporation, which is your constitutional document of your company. Now we have it the other way, where you've got a memorandum of incorporation trumps your shareholders agreement to the extent that there is a conflict in the two. Sometimes investors prefer to put sort of specific protections in the shareholders agreement because the memorandum of incorporation is a public document. So anybody who has an interest can actually go and request that document from SIP-C. Whereas the shareholders agreement is a confidential information. The question is, how do you protect your own interest regarding voting rights, etc.? Well, first of all, it depends on what interest the investor is taking. Typically, they like to take more than 25% because you can't pass what we call a special resolution without them voting in favor of it. The way that you can protect your interests is, I mean, if you hold a majority, at least it's nice that you can pass an ordinary resolution. We've had sort of instances where if you've got an investor who, let's say, owns 45% of your shareholding in your company, and that, you know, later on during the time they sort of divest, which means their shareholding in the company gets less, you can sort of tie them in and go, well, look, you've got these protections, these sort of very strict all-encompassing protections when you hold the 45%. But as you get less and less, you can't have the same protections that you had off the bat. It has to become less. So you can do that and you can say, well, up to a point where you hold, for example, 15% in the company, you can have sort of these protections or less protections. But when it comes to the 15%, you've got no protections in place when it comes to that. Investors I've seen are quite happy with that. It also allows them to continue to be involved in the company. So you know that they're going to think twice about actually allowing their shareholding to go less than whatever it is in the agreements. I hope that's answered your question. Are there any other questions which we might have? I think just to amplify my answer for the previous question, you must always remember that an investor is not out to get you, if I can put it that way. They're there to make sure that they provide you with the assistance that you need, be it from sort of the knowledge that they have, the money that they provide. But they also want to protect their investment. So it's a give and take sort of relationship. You can understand why they want to protect their investments, but also you still want to have control. So during the negotiations, it's a give and take. And we try to provide an instance where everybody's happy as they can be. All right. I think that's it for now. I would like to thank you for watching and listening to the webinar. If you do have any further questions, please do feel free to either contact me or to contact Work in Progress and they will contact me. Thank you very much. And yeah, I hope you have a fantastic day further.